All right, welcome everyone. Welcome to the HR Roundtable. Good morning. All right, good morning, Charles. Good morning, Don. Good morning, Hero. Good morning, JJ Dunn, Alan Hall. Commander Glubiak, Greg Myers. Good morning, everybody. All right, as always, we're going to give people some time to filter in here. We've got a great presentation for you today. Good morning. Good morning, Carlos. Good morning, Aurelis. Andrea Sheldon, good morning. All right, good morning, everybody. Welcome to the HR Roundtable. We're going to be getting started in a bit. Give people time to filter in here. Hope everybody is having a great week. We've got like a little summer going on. It's going to be 76 degrees on Sunday. 76 degrees, sunset at 4:46. Just wrap your head around that. We'll be in daylight savings time, kicked over, and 76 degrees. Just wildness. All right, good morning. Good morning, Michelle. Good morning, Matthew. Good morning, Amin. All right, well, I think people will filter in as they file in, I should say. And we're going to get started in just a moment. Great presentation for you. If anyone is a newbie to the HR Roundtable, you've got a great topic, great speaker today. One of my very favorites.
I think you say that about all your speakers.
I do not. All right. Good morning, Sean. Good morning, Juanita. All right. Very good. Well, let's dive in here. Before we get to start our program, some of you may have seen in the email that we sent out that we've got a great giveaway today from a company called Benetix. And Megan, if you want to pop that screen on there. And my good friend JJ Dunn was great enough to give us an opportunity for one lucky attendee today. Benetix here, description: the most innovative program to utilize live entertainment tickets as a company perk and incentive through a proprietary self-service online portal. And it gives employees and your clients access to their favorite memories, and that in the form of an experience. And in this case, any concert, it says any sporting event, anything that you like. So one lucky viewer today is going to get a chance to go see a show compliments of Benetix. We greatly appreciate that. Thank you, JJ. I'm sure whoever wins this will be very appreciative of that. All right, so I'm going to grab the screen back over here. So before I introduce our speaker, I just thought I'd tell you a little bit about temp positions. My name is Roger Oliver, by the way. I am the Director of Strategic Accounts at Temp Positions, founder of the HR Roundtable. And a little bit about our firm. We are a multifaceted staffing solutions firm. We do temporary, temp to hire, and direct hire across a really wide range of skill categories. We've got multiple divisions that help us to accomplish that task for you. Account positions is our accounting and finance division. So full range of accounting and finance professionals. CompuForce for IT professionals and solutions. HR staffing solutions, close and near and dear to our hearts here. This is our HR division. We have professionals for all facets of HR and on all levels. So whether you need to replace yourself for something that requires senior talent, or you just need an HR admin, we can handle that from top to bottom. On-call counsel is our division for attorneys, paralegals, and other legal professionals. We have a large educational footprint, school professionals being the flagship here. So we provide substitute teachers for charter schools and private schools. And we also have an exclusive arrangement with the city to provide pre-K teachers for what was our former mayor's signature legislation of universal pre-K. So whenever you see all of those community-based organizations that are running pre-K programs that are funded by the city, when they're not able to find teachers on their own, which is frankly all the time, that redounds to us. So we're the engine under the hood of the New York City UPK program. Very proud of that. Convention services, sort of an offshoot of our hospitality division. In this case, everything just geared towards a trade show environment. Temp Positions Hospitality is our division for waiters, bartenders, culinary staff. If any of you are so lucky or unlucky to have the company party as part of your responsibilities in coming months, that's something we can help you with if you are in need of staff for that. Healthcare, one of our largest areas. We have a large footprint in the social service area. So we provide RNs, LPNs, case managers, direct support professionals, and all different types of staff for organizations that provide services to people with developmental disabilities, child welfare, shelter programs. We also staff the Vaccinate New York initiative for the entire state of New York, over 5,000 people in that effort to get people vaccinated in our state, something else that we're very proud of. And to round it up, we've got a logistics division for manufacturing and warehouse environment. A lot of customer service needed there as well, which is something. Temp Positions proper, our general office staffing division for administrative and clerical. The Creative Bureau for all things web. This is our creative division. So graphic artists for design and production, as well as communications professionals. And lastly, TGC Search, which is our executive recruitment division. And we do recruitment for direct hire across all major disciplines that you need for your for your office and operation and everything else. I'm a little tongue-tied. One cup of coffee just does not do it sometimes during the day. Oh, sorry, I should stop screen sharing here. All right. Somebody else can take it back. Megan, if you want to put put something back up on the screen, or go back to our to the website here. Walter, do you want to put the regular screen back up, or Andy, why don't you pop your screen back, pop your screen up there. You can switch over at any time, just so I'm not. There we go. Very good. So I'm going to introduce our speaker, Andrew Singer. is a managing partner of Tannenbaum Halpern and the chair of the firm's employment practice, which offers a full spectrum of legal services from everyday counseling to a complex employment litigation. With extensive experience in all aspects of employment law, he regularly advises companies with various human resources and compliance issues in areas of employment draft and negotiation of employment agreements, compensation structures, regulations and compliance, including wage and hour compliance, which is sort of what we're going to be talking about today, independent contractors, HR policies, including social media policies, anti-discrimination, and other compliance issues, litigation and dispute resolution, and as well as issues dispute resolution for the ADA and other issues. And he's a frequent speaker on employment and law topics and emerging trends. Regularly conducts trainings and seminars for supervisory and managerial employees covering equal employment laws and sexual harassment, the ADA, wage and hour, and many other issues. And Andrew has been selected for inclusion in the New York Super Lawyers, which is a great accolade for 2010, 2011, 12, 13, 14, 15, 16, 17, 18, 19, 20, and 21. And I have no doubt whatsoever that he will be included in the list for 22 as well. And so with that, I leave you in the very capable hands of Mr. Andrew Singer.
Thanks, Roger. That was a very detailed introduction. Appreciate that. Not sure our audience appreciated it, but I do. Welcome everyone. Thanks for spending a little bit of time with me today on this topic. This is a topic that for us employment lawyers has been around for decades, in various ways over the years. And so today, what I'd like to do, because it is one of the areas of employment law that is very often misunderstood, misapplied. There are significant economic consequences. Recently, the last few years, it's come into play in a major way with respect to the gig economy. And now 21 and 22, some shifting in the law. In black and white language, not necessarily in how companies should actually think through whether an individual or a group of individuals should be classified as employees or independent contractors, but we'll talk about it. What I would ask, this is, as there often is, it's a real gray and ambiguous area of the law. So please ask questions, through the Q&A.
Sure. Yeah, and please use the Q&A tab there for any questions as opposed to the chat window. Better to put them in the Q&A.
Yeah.
And we'll answer them as they go. And Andy, you want to do that first poll?
Yeah, let's do that. Let's just see it out of the audience how much we use independent contractors.
All right. So just pop your answer in there, and we'll take a look, and we'll see how you measure up to others on the call. See who's doing what. All right.
Getting there.
Go ahead.
Okay, so clearly a number of you use independent contractors, which is probably why you wanted to listen to this.
Yeah.
Not necessarily a surprise.
You,
so
can,
let's
you can dive into it. I think she'll pop.
Yeah, I think this gives me enough information.
There we go.
I guess let's just go back historically. There were two primary reasons that it was a big issue, let's say, and just for context, I'm 30 years into practicing employment law. So going back to my first, let's say, decade and a half, it was really overtime related issues. The applicability of wage and hour laws, because if you're an independent contractor, you're not covered by employee wage and hour laws, so would not be entitled to overtime. So that was a very large issue. And then it was in workers' comp and unemployment insurance audits, where the government came in and said, hey, wait a minute, you've got a lot of folks you classifying as independent contractors and you're not paying unemployment insurance or appropriate workers' comp. And those were the two primary ways we got involved in the issue of misclassification of employees as independent contractors. Those are still, by the way, very important, and we still see that over the years. Larger companies who utilized large groups of independent contractors, benefits became the issue. Those independent contractors realized, hey, I'm missing out on a ton of benefits, and there was some major litigation the last 10 to 15 years over that. And then recently, the gig economy and almost entire workforces that where the companies utilize the benefits of classifying the bulk of their folks as independent contractors. Uber, great example. We'll talk about that a little bit later. But that's kind of the history of this issue. As I said, it is a gray and ambiguous area. There's various tests in the Internal Revenue Code, federal regulation, local and state regulation, and uneven applicability of these standards within government agencies. And I'll talk about how we approach the analysis and whether it's in a litigation in court or working on behalf of our clients with the government. And that'll help you hopefully be able to better analyze whether you're appropriately classifying folks. So let's dig in here and kind of get started into the substance. So, right, there's people who do work for companies. It's employees and independent contractors. Those are the two basic classifications, much more complicated than that. So employees, they're people who the company hires to work for them. And the employer figures out what your job is, how you're going to do the job, and they determine your salary, your compensation structure, whether you need to be trained, supervision, all that stuff that companies do for employees. Independent contractors are different. They're folks who undertake contracts and they provide a service in exchange for a fee. I think the best way that I've figured out how to describe an independent contractor to start is you're a plumber, right? You hire a plumber to come work in your office, your home. They are a company. That plumber is trained to do a job. You have nothing to do with their training. They bring their own tools and supplies. You have nothing to do with that. They determine how they're going to do the job, how long it's going to take, and you pay them a fee for that. They can make money or lose money on the transaction. They work for others. They don't only work for you. That is a classic example of an independent contractor. It's not always that easy, though. So here's some examples of what it means to be classified as an independent contractor. Oftentimes the employer will designate someone as an independent contractor, and the worker will agree, or the worker will say, I want to be an independent contractor. That good for you? I have a corporate entity. You can just pay my corporate entity. And everyone says, great, you'll be an independent contractor. That literally has no relevance under the law, whether that person is properly classified as an independent contractor. Consent or agreement between the two parties, completely irrelevant. Another common misconception is that a written agreement between the company and the independent contractor that calls that person an independent contractor, therefore they are an independent contractor. Again, actually irrelevant. The fact that there's an agreement that's in writing signed by both doesn't matter. That's not to say that there should not necessarily be a written agreement. We'll talk about that. A contract term that outlines the right of control may establish an employment relationship, even if the employer allows the individual significant freedom of action. So we are often asked to draft independent contractor agreements. And we start with a template ourselves, and we'll sometimes see a draft from our client, and we're looking at it, and it just reads like an employment contract. It just says independent contractor. Or even worse, it'll be called an independent contractor agreement, but there'll be references to employment or employee or employed in the agreement itself, which is not a good idea. And then another real significant issue that we hear from many of our clients is that, well, it's a part-time, so they're only going to come in, they're going to work 3 weeks on something, or it's 1 day a week, so they're an independent contractor. No, that very likely is called a part-time employee. So that again, issue in and of itself does not necessarily mean if it's less than full-time, that individual is properly classified as an independent contractor. This is really important, and we'll talk about, there's a new federal rule being proposed, and there's various tests that may shift. But understand that no matter what factors you're reading about that's in the law, that's in a regulation, and no matter what the law says, that individual who's making that decision looks at a variety of factors, of facts within the relationship between the company and the individual, and in their own mind will make certain assumptions or judgment calls, which is what makes this area of the law so challenging. There's several factors that are, sometimes in some complicated situations, there's, 15 to 25 facts within the relationship that are relevant to a determination whether an individual is an independent contractor or an employee. One kind of rule of thumb, I thank my assistant who put this together with a nice thumb there. If the independent contractor performs the same kind of work that is performed by that company's employees, that worker is probably misclassified. If it is really difficult under the law to have two people relatively doing the same thing, and one is an independent contractor and one is not. Many times we'll see a client will call us with a situation where they have someone who was an employee full-time, and they're like, well, I think we could do this part-time, and the individual and we're going to treat them as an independent contractor because now they're part-time. And the issue is, you can't have someone who was classified as an employee doing the exact same job that is then suddenly an independent contractor. That's usually a good rule of thumb. That's a no-no. All right, here's just some, again, basics on ways to look for traits or conditions that are usually associated with either an employee or an independent contractor. Someone is paid hourly or by salary versus simply a single payment at the end of the project. That's a key distinction. Someone who works solely for you, even if they have the right under your contract to work for others, but if they're really just working for you full time, versus someone who literally at the same time they're working for you works for multiple clients. That's a key distinction. Where the employer determines what the work is that needs to get done, versus the company and the individual saying, okay, we need this project done. How are you going to get that project done? And the individual says, okay, here's my skill set, and this is how I think I can accomplish this for you. Two different ways of looking at that relationship. On the employee side, is that relationship at will? Is there a defined term? You can only be for a period of time, or even terminated only for cause or under certain conditions, versus, someone who says, I'm being hired to do this project. When the project's over, our relationship ends. Again, it's really what it's, you try to look at it. Does it smell like an employee relationship, employer-employee relationship, or does this really sound like an independent contractor? The individual is supplied their tools, a computer, a phone, paper, pens, other equipment, or does that individual come with their own equipment? The last issue is who decides the manner and means of performing. That's a big one as well. I really like to start the analysis is simply this slide right here. Who has more control over the work that's being done? And the reason that I focus on that probably more than any other factor is over the many, many years of doing this, the governmental agencies, that is their focus. And so if we can satisfy them that individual classified, or the group of individuals classified as independent contractors, truly work independently without supervision, without direction and control of the company, much, much greater likelihood that they'll be determined to be properly classified. So that kind of, for me, is the starting place, and almost the ending place. If you can really satisfy that, quite often, if you button up some of the other places, and we'll talk about some details along the way, you'll win that battle, whoever you're battling with. Okay, so here's some of the factors, go into a little bit more detail of what we've been talking about. Requiring attendance at meetings or training sessions. The more you require that, the more it looks like that's an employee. Requires prior permission for absences, right? Sick days, paid time off, anything that looks and smells like that is really going to, be a red flag that that person is really an employee. company sets the pay schedule and the rate of pay, as opposed to the plumber situation who says, yep, I can fix your sink. That'll be $27,000. That's one of the negatives of the Zoom is usually, you get to hear the laughter at one or two of my jokes. Providing facilities, equipment, tools, and services. We talked about that previously. Setting working hours. That's a big one. If there's a schedule, you're working 10 to 3, 5 days a week, and that's mandated by the company, that is quite often looks like an employer-employee relationship, as opposed to our offices are open. Here's when you have access or can do the work, or you can do it remotely anytime you want. Freedom there, independence, again, is the key with respect to working hours. Assigns work essential to regular business of the company. Again, that kind of is related to the issue. If you have employees doing that job or a similar job, it's hard to have an independent contractor do that job. Not impossible, but just more challenging to have someone properly classified as an independent contractor. And you'll see that comes into play later in some of the new regs under federal law, is how integral is the work being performed to the company's regular business. Chooses when, where, and how the work is performed. Approval, right? It's one thing to review a project and say, okay, it's completed, or wow, this is a crappy job or a great job. And if it's a bad job, yes, we asked you to do A, B, C, and D. You forgot D, you got to go do D. That's different, right? As opposed to performance kind of related approval. Again, think of the distinction between employees and independent contractors. Exclusivity. So that's a big one. We will often either review independent contractor agreements from our clients where there's exclusivity, or they'll say, hey, here are the terms, and the client will say, and for the period of time they're working for us, they're not allowed to work for any competitors.
Andy, can we take a question?
Yeah, absolutely. That just smells like an employer-employee relationship. So that's something that's really important. If it's important to you that individual is exclusive, cannot work for competitors, that might outweigh the risks associated with misclassification and the benefits from being an independent contractor economically. So you really have to think through that particular issue, particularly if you're going to have the relationship documented in an agreement. Sure, Roger.
Yes. So a question here from Greg asking, and he asked this a few minutes ago, probably relating to a point you were making a few minutes ago. Does this mean if I hire a technical recruiter on a 1099, the person is not an independent contractor if hired to supplement the workload?
That's a real issue. That there certainly might be misclassified there. I mean, if you're just hiring someone to come in, you need a recruiter that's doing the same job as other recruiters. You just need for whatever reason, there's a large job order where you need to find a tremendous number of candidates and you're looking for some supplemental help there. The way I would try to focus on exclusivity. Can they at the same time be working for others? Do they work for others? Do they have their own company name? Things like that, to where it can really look like they are independent, but that's going to be a challenge. It's a challenge, again, like I said, to have a same job set of responsibilities at the company, and particularly if it's integral to the company. In a staffing firm, your recruiters are integral to the business. That could be a real challenge if you're audited. or there's an issue of overtime, et cetera, and that, person goes to court to get the benefits under the wage and hour laws. So that, that again, a good question. And that's the type of analysis that you have to do. All right, Roger, was that it or?
Yeah.
Okay.
Yeah.
Thanks for that question. Yeah, specific questions are helpful here, as I said, just with specific examples, just so I can talk through the way I would analyze it. And rarely can I give you a definitive answer, unfortunately. I can give you a likelihood. I've, particularly with the government, and I'll say this, some governmental investigators are a little lazy, some are not. You can get lucky. I had for a client, they were being audited, and they had probably about 25 to 30 individuals classified as independent contractors. And they had about 15 of them, give or take, who had quote independent contractor agreements. The auditor was just so happy to say, "Oh, okay, just send me the agreements, and then we'll classify those as independent contractors, and we'll just look at the other ones." So, that was great for the client. Sometimes you can get lucky in that regard. So and I say that there's a reason to have agreements in place, because you never know whether that situation will arise. So you're better off having agreements than not having agreements.
Hey, Andy,
yeah.
We have a couple of questions here.
Sure.
And from Christina asking, can an employer provide training suggestions to an independent contractor to improve the quality of work?
The answer is yes. The way I look at it is, you hire someone who has a certain skill set. Maybe it's someone that you've had this need at other times, so you have experience with, for your business, the best way of doing it. And to make suggestions, I think, doesn't automatically negate the independent contractor relationship. I would be careful on how much direction that you're giving. I also would be focused on whether that was in writing, whether you had something set, like a PowerPoint or a training memo that would that to me would look more like an employee relationship versus just in a conversation or an email. Hey, we're talking about how this project will go. Here's some of our thoughts. That more like an independent contractor relationship. Go back to the plumber scenario. You're allowed to say, by the way, we had this leak before. This worked in the past. This didn't work. Here's where our water is turned on and off. It's not like you have to, stay completely silent and have zero ability to impact or influence the job. It's just how much.
Christina had a follow-up question here. I think, given your answer just now, I think I know the answer to this one. She said, can employers pay or sponsor training for independent contractors to improve the quality of their work?
Yeah, for me, that just smells like an employee that you want to train, right? A true independent contractor has the skill necessary to get the job done. That is why you are hiring them. So let's move. Let's stop using the plumber, even though it's my favorite. Let's start using a branding. You're hiring a branding person to help you change some of your branding. You're not going to pay for them to be trained on how to do that. They know how to do that. You're hiring for them for that specialized skill set. That doesn't mean that you may have a marketing branding person that works for you who could work with that person and provide input and even work side by side in different experiences. So hopefully that makes sense.
And we have a couple of more.
coming in fast.
Yeah, I know. Person asks as an agency question here, how do agencies factor in regarding using temp to perm services through an agency, but directing the work of the temp?
Well, again, I go back to, if it's a temp to perm, again, not relevant to the independent contractor employee issue. There are, sometimes you get involved with that agency who they're paying the person as a 1099, you're paying the agency. There's potential joint employer risks there. That relationship in and of itself doesn't change what we're talking about. You should still do the same analysis. And if the agency is training or doing the, directing how the work is done, they're the quote joint employer of record, or they're paying by independent contractor, or you are, that is relevant, and it might improve the analysis, but you still have to go through everything that we're talking about.
Yeah, and I will, as Andy knows, with respect to our company temp positions, all of our temporary employees are W-2s, and we never.
Yeah, and so there's truly a benefit in my mind to that. I do have a certain level of concern when you use a staffing company who does not treat everyone like a W-2, because that just adds to the risk factor, because you may, as you hiring that agency, you may not necessarily even have all of the information or facts necessary to determine for yourself, are you comfortable that this person's an independent contractor, or should they be classified as a W-2 employee? So if you are using an agency who is paying as an independent contractor 1099 basis, you still got to do all of this. You really do. Was that it, right? Was there another question, Roger? Or that
there are a few other questions here. Let's see. This question here: can we touch on any suggestions on communication cadence when rolling folks from a independent contractor situation to an employee?
Yeah. By the way, that is more likely to be okay than the reverse, right? Employees to independent contractors almost. I actually have never been asked to analyze a set of facts where I said, no, that works. The reverse may be true. That's possible, where you have an independent contractor and now you want to make them an employee. You do the same kind of analysis, but you need to be careful because they may have been misclassified as an independent contractor to begin with. Right there, if they're doing work that is really integral, that's a staffing company, you're hiring them as a recruiter. But that can be done. You can have a recruiter who truly was an independent contractor working on their own, had many clients, had their own website, business cards, email, etc. And then you now want to hire them just for you. That can work. That answer the question, Roger? I'm not.
I think so.
Okay.
And lastly, we have someone asking, where can we access a template of an independent contractor agreement?
I don't know if NISO or ASA has that. We don't just share my firm, but I'm happy to talk to you, no cost to discuss the issues with you. So whoever's asking that wants to reach out, please feel free.
Yeah. Very cool.
All right. Here we go. Let me see if there's anything new on this. No. Yeah, so let me talk a little bit now. Sometimes I get ahead of myself. It's okay. You've heard me mention a little bit about profit loss, their own entity. So here, you see independent contractors typically in business for themselves. So sometimes one of the biggest factors that we can end the debate quickly is, is the issue of profit or loss on the table? If you are paying someone a salary as an employee, they're not going to lose money on the transaction. They're working for you, you're paying them. It doesn't work that way. They don't have maybe commuting costs, but minimum wage should cover the commuting costs, may not cover other costs of living. But whereas if you have that independent marketing consultant who's a contractor, they have a website, they should have their own business insurance, business cards, their own phone, their own email address, website host costs. So arguably they might lose money on a transaction. That's a business, right? And so the more you have a relationship where that individual or individuals have their own independent business where they can lose money on that project, that's an easy one. That's often a winner. That particular issue. Do they advertise? If they advertise their services, and you can show the auditor those advertisements and say, hey, this person, they're out there looking for work. We're just one of their clients. Great evidence that it's an independent contractor relationship. You don't get much better than that. Okay, here's some more factors. I assume some of these that we may have talked about, but sets or negotiates his or her own pay rate versus saying, here's what the job pays. And I'm not talking about someone says, well, how about instead of 60,000, you pay me 62,500 on a salary basis. It's a project. Here's what I get paid. Here's the pay rate. And that individual sets the pay for that project. They reserve the right to hire help. That's a big one. If they actually have people that help them in their job, that's again looks much more like an independent contractor. I just kind of went through that independently established business. And again, simply because you're paying an entity does not mean they're an independent contractor. That is, I've heard that over the years so often. It is one minor factor. So please don't just assume that you're paying someone's corporate entity and therefore they're an independent contractor. Again, determines the means by which they complete the task, assumes risk, profit, and loss, is free to say, nope, I'm not doing that, or I'm not going to do it in that way. Again, freedom how to do the job, or saying I'm not, I'll do this for you, but I'm not going to do that, as opposed to where you hire an employee, here's the job. They can't pick and choose what they want to do, how they want to do it, when they want to do it. If they have a place of business, that would be fantastic. A WeWork office that they maintain, or something like that. They have equipment, supplies that it's their cost. You pay for that. That's, automatically looks like an employment relationship. Exclusivity, and sets their own schedule. And I apologize for repetition. I just do think it's important. Just again, over doing this for 3 decades, some of the same mistakes from clients are made so often. Let's talk a little bit now about what I emphasized earlier. It's how you direct and how you control. That is so critical. Are you requiring the individual to prepare reports for you, to attend meetings, to attend regular meetings, right? So is it automatically a problem if someone, let's say, again, a marketing and branding consultant, you have your own internal marketing team, and they come to a meeting to hear what it is that you're trying to accomplish, that you want that independent contractor to help you with? No, that attending that one meeting in and of itself is not necessarily problematic. However, if let's say they believe it's a 3-month project and that marketing team meets 2 or 3 times a week, and you're requiring that person to meet 2 or 3 times a week, that looks like a temporary employee as opposed to a contractor, because they probably don't need to know everything that's being said at these meetings if they're truly just an independent contractor. So be careful in those meetings what you're talking about. Have them just show up to that meeting where it's relevant for what the project is that they're doing, that the rest of the marketing team is not doing. Supervision. You cannot have that independent contractor reporting to someone in the same way an employee does, or who's, you know, on a regular basis saying, here's what I've done for the day. That branding person who's, you know, working on rebranding your website isn't reporting to you every single day what they've done. There's maybe stages of that project where you're sending you, here's completion. You know, let's say there's 4 stages and they send you, here's stage 1, or here's what I've done. Stage 1 will be completed next week and I'll get you that, versus every day you're getting a report what they've completed. That's not really an independent contractor relationship. Training, we've talked about a little bit, answered some questions on that. On the company's premises, so be careful about that. If you're requiring it, if it's not necessary, and if it's not the decision of the contractor. If the contractor says, I could do a better job for you, I prefer to do it on your premises. If it's not required, that's okay. Just make sure that's clear that it was their decision. I'd like something in writing that says that. That would be beneficial. Again, direction on how to accomplish the work. Can they reject assignments, right? Someone works on and off for you. Can you say, hey, we'd like you to do this? Can they just say, no, I'm, not available, and that's okay? They suddenly are. That doesn't change the relationship. They're setting their own hours, how and when. That really is, again, a critical factor. And can you terminate them at will? Many independent contractors who truly have their own business, and if they sign up for a project for you, so they're committing their time, they're now not doing work or agreeing to do work for others necessarily for a period of time. Oftentimes you just can't cancel it on the spot. There's a fee you have to pay, a cancellation fee, something like that, that looks more like an independent contractor relationship. So be careful. If you can just end it, you owe them no money. That looks more like an employee at will. Again, I want to emphasize, these are separate factors. In and of itself, it might not necessarily be determinative. Just keep it in mind.
Okay, I think we have we've got a poll question. Megan, if you want to pop that up. And then I think we have a few other questions here. Okay, what departments do you typically use independent contractors for? Oh, we've got 2 questions here. And how does the recent DOL rule impact your use of independent contractors? Just a two-part. All right, so we will wait for the answers to pop up on that. In the meantime, we'll get to a couple of questions here. One from Ms. Dukas asking, is it mandatory to request independent contractor for proof of workers' comp or other liability insurance? What happens if they don't have it?
Yeah, good question. The answer is my rule of thumb is to make sure that there's coverage, and there's oftentimes ways of covering independent contractors. But I would make sure that there is coverage.
Okay.
And if not, just make sure you're aware of it and you're okay with the risk.
There's one here from Greg. If you misclassify someone, does the company have an obligation to pay taxes that they should have paid if this person should have been an employee.
Yeah, so I have a whole couple of slides on the consequences, and that certainly is one of them. Yeah, absolutely a risk. And there's some slides, and Roger, I saw someone earlier. Do you share the PowerPoint with everybody?
I typically will do it after.
Okay.
We'll
Yeah,
send
so
it a follow-up.
there's some slides on it, and if I don't get to everything or whatever, we get stuck on some questions. It's in here.
Okay.
And then I will offer to everyone, if you have a follow-up question, please email me, or you can email Roger, and we'll answer the question.
We'll definitely make sure that that everybody has your information there. Okay, so a lot in the IT and creative.
Common.
Right.
All right.
Then the second part, this for the most part, the new rule, 57% no effect.
I mean, that's kind of my own view, by the way, and certainly the view that many companies have taken, because they're going to just say that we just focus on the relationship, and the focus that the government is shifting. If you do the full analysis, I actually think it's not that big a deal, but we'll talk about it towards the end.
Simone was saying that you skipped point number 5 on that. I guess it was probably on the last. There, it must be here, I believe.
Company direct the worker how to accomplish. If that is the one, then yeah, you really can't direct an independent contractor how to do their work. They have the skill, they have the training. You can work with them on and define the scope, what you want them to accomplish, meaning what's at the end, but how to do it, that's when looks much more like an employee.
And what about, we have someone asking, can we hire seasonal staff for 3 months performing the same work as our DSP's direct service professional? And
yeah, that would be very challenging for me to satisfy the independent contractor test. If they're doing the same work, they're just seasonal, you need more of them. That sounds like a seasonal employee.
Yeah.
Here's just some of this. I'll go through this quickly. Some of this we've talked about. Their own insurance, right? That looks like a business. Are they a representative of a company, having their own business cards, email address, their own corporation? No exclusivity, no specified end date, right? Is the relationship continuous? Looks more like an employee. If it is, they have their own website, advertise to the general public, their own tools, substantial skills, like they have degrees, they went to school, they have, those skills, that's helpful. Invoices, I haven't mentioned that. True, think about that. Those, that marketing consultant, they have a company, they work for their own company, they're going to send you an invoice. You're going to pay that invoice. Charge per project, or is it really there's a salary or paid by the hour? Have an occupation business that is distinct from the company, right? Obviously, if they're receiving benefits, or you're paying them and deducting anything, cost of equipment or anything like that, that's certainly employment. This is a good one. Are the workers' expenses reimbursed, right? Think about what you do for your employees, right? If you profit or loss, you pay for your own expenses. That's one of the ways that you might lose money if you misjudge the cost. That doesn't mean you can't be reimbursed ever for expenses, but just know that that'll be a red flag. There'll be a deeper dive into reimbursement of expenses. And then last, this is important. Receive an employee handbook or other employee policies. 20 years ago, we would often say, no, don't send them your employee handbook or other policies. That's for employees. Today, there are actual laws that say independent contractors have to comply with certain policies, right? Anti-harassment, as an example. So the answer is you can, but I wouldn't just send it saying, here, you must read all of this, because they don't have to. I would be very focused and let them know what you want them to familiarize themselves with and what they have to comply with. That's the way to handle that. And that's an important factor, because that you might just do, not even thinking about it. Just send it to them, because there are policies that they have to comply with. Just make sure you're showing that there's a distinction between independent contractors and employees. Sorry. So independent contractors, right, not entitled to benefits, 401k, group health. That's been, subject of litigation for large companies who have large swaths of independent contractors. 1099 versus W-2, right? No withholding, no payment of these employment-related taxes or costs, and not subject to the wage and hour rules like overtime. One thing that right? Employment is still robust. We hear on the TV people predicting recession. Who knows whether they're right or wrong. However, if in fact there is a recession and the job market is not robust and companies are laying off people, one of the easiest ways to get caught and get in the crosshairs of the government is when you have people that have been classified as independent contractors filed for unemployment. And they do it often. And that's when you will get audited for workers' comp, unemployment insurance, not necessarily the wage and hour laws, but that's how you'll get that letter that you're being audited. The other risk factor that I think is greater than normal, in the past, someone might have filed for unemployment. There's an audit. And it's just unemployment insurance. It's only one of the costs, right? As you see, there's multiple costs involved with having employees. That part of the government who's only focused on unemployment, they don't talk to any of the other governmental agencies that you may owe money to. We're starting to see that they've threatened to be doing that over the last few years. I think they might do that much more often going forward. So the risk is much greater that you're now dealing with multiple governmental agencies.
I've got three questions here. One regarding travel expenses. If the project requires traveling, who's responsible for paying those expenses?
Yeah, again, typically, in my world, if you want that person to be an independent contractor, have them built it into the fee. Talk about that in advance, by the way, right? You might say, requires travel and I'll pay you for it. So rather than reimburse them, just agree that instead of a $5,000 payment, you'll pay them $6,000 and don't even mention, right? That's just one way of handling that. And other related expenses, just increase the cost of the project.
Someone asking, can you elaborate on what generally triggers a DOL audit? Since as we had a independent contractor go file for unemployment, which ended up in an unfavorable audit.
Yeah, that's the biggest way. The unemployment, people filing who are classified as independent contractors by far. Workers' comp audits, that's another big area. And then if you have independent contractors that work more than 40 hours in a week, I'd review that real carefully. That's probably your biggest exposure. If you do have that and you have a number of independent contractors who work more than 40 hours a week, subject, because then they go talk to a lawyer and the lawyer says, yeah, I don't know that, I think this there may be a misclassification here. File a class action lawsuit, and that's another big way.
Here's another one. Should it be noted on the contract that the agency is not responsible to provide unemployment benefits?
You can put anything you want in the agreement. The fact that it's in the agreement doesn't necessarily mean anything. Let's analyze the facts, analyze the relationship. Not that you shouldn't have as much spelled out in the agreement. We pull in all the bells and whistles we can so that it looks on paper like an independent contractor relationship. But unless you have that lazy governmental investigator, they're gonna say, great, okay, and you have the agreement. Let's now talk about every factor that you made reference to in the agreement.
And lastly, we've got Joe who's asking, why is expense reimbursement now an issue?
It's always been an issue. It's always been something that the government looks at, or courts look at, whether someone is classified as an independent contractor. That's not new.
All right, there we go.
So here, some of the following expenses and why companies like to have independent contractors. Here's some of the things you avoid. Most of this is pretty obvious. So it is beneficial to the company, no doubt. You just have to examine what are the costs if you're misclassifying. So, and then here's kind of answered a little bit in advance, but if you look in, there's some crazy numbers here that you can be exposed to. You can go back 3 years typically is what the government will do. There are criminal penalties. Again, more than 5, 6, 7 years ago, none of this, unless it was incredibly abusive and repetitive, where criminal statutes came into play. Government is more aggressive now. Some of it is locale, right? Some of it is, New York City is incredibly employee friendly. So much different than, let's say, Florida and other states. It's, politics do have an impact on employment laws and enforcement. So, if you have folks in, multiple states, as many people do, you do have to pay attention to that. So there's a lot there. There's a lot at stake. Here's just some, spelled out a little differently, but it can be huge, particularly if you have a large part of your workforce that you classify as independent contractors. And part of the analysis when you're bound, because it isn't, you might have a situation where your employment lawyer says, wow, that's 50-50. I don't know what the government will do. You make an assessment on business risk. If you have 3 independent contractors versus 300, that's a very different risk. And why companies like Uber and Lyft, who truly almost their entire workforce is independent contractors, it's a bet the farm issue, right? Bet the company issue. So let's talk, right? I mentioned the gig economy, good segue, talking about Uber and Lyft. That really, over the last few years, that's, individuals wanting the freedom, individuals wanting to just say, hey, I'm going to go to work now. I'm going to work for 4 hours. That's all I want to do. And then I'm going to get paid. My agreement with the company works. That was a huge shift in our economy. A lot of advantages to it. What's happened over the last few years is now individuals are realizing, okay, that was great. My freedom at first, not having withholdings from my pay, that was great. Economic freedom, flexibility, tax benefits. But what now have I lost, right? And so, benefits, health insurance, paid time off. There's a lot more paid time off laws now. So there's a lot more benefits economically to individuals. And that's kind of shifted how companies are viewing, how individuals who work for these companies are viewing it. And there's been a tremendous amount in the news, new government regulation and litigation. So if you happen to be a company that utilizes a significant number of independent contractors, you got to really be careful. And I would follow these litigations and the issues that they're fighting over, and then try to be proactive are my independent contractors going to look at this and say, oh my, yeah, we're losing all these benefits where you're at risk. Same thing now with unionization, right? So many individuals are looking at what's happening at, Starbucks and Amazon, and it's in the news every day. What am I losing by not being unionized, by not being an employee? Got to really, pay attention to that. Know your people. Ask what's going on. Take big believer in surveys of your folks. Find out what's important to them. So here's a little bit on the law, and I put it at the end because I view what we already discussed that to be really the most important way of analyzing this. Here, the current test, it gives weight to 2 of 5 factors. We talked about it, the degree of control and the opportunity for profit and loss. It's been viewed as more employer friendly because the focus is just on this. And so it's a little clearer. But again, I haven't been involved. No one on my team has been involved where we're not doing this full blown analysis, looking at all the factors and, arguing with the government or the court or other lawyers on it. The new proposed rule expands on the factors to be considered. They're set forth here. None of them, by the way, are factors we haven't talked about. It's really just, in my mind, the government trying to shift it to a way of benefiting individuals, giving them more, an easier path. And no judgment on my part. I just think that's what they're trying to do in this area of the law. Just leave that up for another second. Again, just comment on the bottom right, the type and specialization. So the more specialized the skills, the more degrees an individual has in that area, the more certifications they have, that really goes towards their ability to be in business for themselves, where no supervision, no training, no direction and control. They just understand the work that you need them to do. They're the expert in it, and much more likely for them to be an independent contractor in that case.
All right, excellent. Andy, thank you so much. Are we?
Yeah, we're back. I think there's just some at the end on some of this new proposal.
Okay, I'm sorry. I should jump.
Yeah, no, that's okay. We're about finished. Okay. Again, it really, in my mind, and sometimes we don't expect our attorneys to be minimalist and not make a big deal out of new laws. I'm really, for me, again, like I said, we're going to do the same analysis that we've always done. This may shift a little bit on how the government can focus on it, but we're going to focus on all the things we brought up in this program before even talking about the new law. But as you can see, right now, there's about 900,000 gig workers in New York State. So this, and there's a tremendous amount of companies that utilize independent contractors. So clearly the fact that there's a new rule being proposed means the government is going to focus on it. So there's a higher risk that you will get in the crosshairs of the government. Just quickly, there's a New York City Freelancer Isn't Free Act. So for many independent contractors, there's a requirement to have a written agreement. And here's just some of those requirements. So if you don't have written agreements with independent contractors, that's something that you really should focus and make sure you're not in and of itself violating the New York City Freelancer Isn't Free Act if you have folks in New York City. We've covered all of this, I believe, in various ways. Yeah, just notice the sexual harassment prevention training at the end. And that's it. Thanks, Roger. You've
All
never,
right,
I just
excellent.
want to make sure I finished.
Absolutely, absolutely. We are going to announce our contest winner in a second here, but we definitely want to give a great thanks to Andy for another fantastic presentation. If you did not receive your invite to the HR Roundtable from us directly, and you would like to be part of our regular distribution list, then please send me your email address so that I can make sure that that you are included in all of our HR Roundtable messages going out, including the follow-up, because you're going to get a follow-up for this, including the video itself and the slides as well. All right, so Megan, who is our winner?
Thank you, everyone, for joining our webinar today. Our randomly selected winner of 2 tickets to any concert or show anywhere they want is Terry Thomas. Congratulations, Terry, and we will connect you with JJ shortly after the webinar.
All right, congratulations, Terry. And I thank you all so much for spending this time with us. Please send any questions that you have to Andrew Singer directly. You'll get a follow-up email from us with Andy CC'd on there so that you guys can have a dialogue. And that's it. Everybody have a great day, and we will see you soon. Walter, take us out.